Right, it's recording, so I'm going to be professional now. Yeah, welcome to today's webinar on the Renters' Rights Act 2025. I know that some people will be joining late, so I'm going to start off anyway because there is quite a lot to cover. I'm going to do it. I'm going to strip it back into a certain extent. So some of it you will already be aware of, but there's a few questions I'm getting from people. In particular, landlords are asking them. I just wanted to clarify because I fully accept it can be a bit more confusing in terms of how it's working. So yeah, we'll just go through it. Ask any questions as you've done already in the chat box. You can type away. I will record it, or the recording's on, so I will upload it to my YouTube channel. So if you need to rewatch it for any particular reason, you're more than welcome to do so. The first thing I want to say is, if my button works, that is, I'm still here, as in I'm still in the UK. People think I've disappeared off the face of the planet. I haven't yet, so just to make you aware of that. I am still 100% here. Oh, okay. I still need to admit people, but I thought people could come in without the need for me to admit them. Yeah, so I'm still here. I haven't gone traveling yet. It's not until the 16th of May. When I say traveling, when I'm disappeared from the UK, I'm leaving on the 16th of May. So I obviously deliberately planned my travels after the Renters' Rights Act come into force, which might be a bad thing, actually. I don't know. We'll see what happens. So I don't leave until the 16th of May. So I'm still in the UK. I'm traveling around Europe first. So I'll still be available during the normal office hours. Then I'm going to Asia. But again, I'll still be working during the normal office hours. It would just be obviously later in Asia. That's 6 or 7 hours ahead. So I'll be working slightly different hours, but I'll still be available by email mainly. And I would say probably by WhatsApp. If people are going to phone me, then I would appreciate probably a phone call via WhatsApp. I think most of you will use WhatsApp, but I will email all my subscribers in terms of the helpline and documentation pack to make them aware that's what's happening. So contacting me by WhatsApp would be the preferred method in relation to contacting myself. But I'm still here in the UK until, sadly, the 16th of May. I'm looking that way because that's where my screen is. I'm in a hotel room, so I've connected up to the TV on the wall, which is over there. So I need to stare that way to see what my slides are saying, if that's the right way of referring to it. So just make sure I change it correctly. So one of the questions I get, and I fully accept sometimes the use of terminology really confuses people. So when I was talking about the written statement last week, that is basically what's going to be contained within your tenancy. So some people say, what's the difference? Well, they are the same thing ultimately. And I know lots of landlords will probably ask that of you. I don't think any of you have had that question, but I fully accept sometimes people tend to forget, or the use of words causes confusion. And that's probably one of the first things that I think a lot of people have mentioned, that what is the written statement separate to the tenancy? No, they're basically the same thing. As I was just saying last week, and you can find the written statement YouTube video on my channel. So if you wanted to watch that from last week, you're more than welcome to do so. You can find it on my YouTube channel. So it's the written statement, as I said last week, is the basic requirement in terms of wording which the government will need for you to provide to tenants from the 1st of May. So any tenancy agreement that you create and execute and signed on or after the 1st of May, you will need to contain in some shape or form, and most likely in the tenancy agreement, the requirements of the written statement. So what we discussed last week will be in all of your agreements that you probably get from all your suppliers, whether it's me, whether it's Good Lord, whether it's my old employers, TFP, whoever it's going to be, they will have, I would assume by default, the minimum wording required by the written statement in their tenancies. So in a sense, you don't have to worry about it as an agent. And last week's YouTube video was all about explaining what was in there and why it was in there, potentially, what it means. And I think, as I said, most of it was relatively common sense. I think I made reference to, for example, the Fitness for Human Habitation Act, which is what a lot of people aren't really aware of. So they've made mention to that. As you know, there was mention about adaptations in terms of disabilities. And there was obviously a clause there regarding the tenant's ability to request a pet. Jack's mentioned earlier prior notices. Any prior notices should be basically mentioned in your agreement. So from that perspective, that's what the written statement requires. So the written statement and the tenancy, in terms of how we work, are the same thing, because the tenancy agreement will contain the minimum requirements from the written statement. So that's basically what this particular slide is saying. So from that position, obviously in terms of your tenancy, the written statement might be a couple of pages worth of information. Then the other 10, 15, 18 pages that you might have are going to be information that you would put in there yourselves as the agent or the landlord. So I said the bulk of it will be stuff that you would add as the landlord yourself into the tenancy agreement. And as for those that have attended my courses, I think the tenancy agreement will become even more important after the 1st of May. Because obviously you might only be able to rely on those clauses if you're seeking possession under ground 12, which is breach of tenancy. So again, without trying to rerun the whole without trying to run the whole renters' rights course again, tailoring your agreements, and I can't understate the importance of that, is going to be really important. And I think that will show the value of letting agents in particular to their landlord clients about how you tailor the agreement to make sure you have the best ability to get possession of a property back. So that's going to be really important as well. And as I said, between now and the 1st of May, I know there might be a couple of landlords on here. Again, how what is your tenancy agreement fit for purpose? So for those that subscribe to my pack, I've got my draft assured periodic tenancy ready. I've not released it yet, but as I said last week, if you want to see a copy as one of my subscribers, I'll send it to you, but it's only a draft in the sense that we don't have the official wording confirmed yet. So I'm a little bit reluctant to say you can use it because it may change. It's unlikely to, but I don't want to obviously be awkward by sending it out and then everyone says, well, we started using it and now the wording has changed. So at the moment I'm keeping hold of it, but if you wanted to see a copy to see what it looks like, so long as you don't use it, obviously, then yeah, you're more than welcome to have it if you are a subscriber to my tenancy agreement pack. So that will be out probably as soon as they confirm it's the official wording, then I will send it out to all my subscribers. And the last point on my slide there is about the civil penalty. As you know, if you don't provide the written statement or the requirements of the written statement, and again, evidence that you've done that, then potentially you could be up to a civil penalty up to £7,000. And as I was saying to Jack before some of you arrived, if you don't serve a pre-notice ground, if you require it, and then you go to court on it, then potentially you would be liable to a £7,000 fine as well. So for student lets, for example, if you didn't serve a ground 4A prior to the tenancy being signed, and then you relied on ground 4A the next year, then that potentially could land you with a £7,000 fine. So pre-notices are important if it's applicable to you. And in the majority of cases, it won't be applicable to you because you won't need it. So student lets, yeah, HMOs, then potentially if you're using ground 4A, you'll need to serve a pre-notice. If any of your landlords are a religious establishment and they need possession under ground 5, then that's a pre-notice that you would need to put in your agreement. So if you were relying on ground 5 as a landlord, then you couldn't use that ground, or you could use the ground, but you would be fined for using that ground, which sounds a bit strange, but that's how they've worked it under the Renters' Rights Act. So that's the written statement and tenancy agreement, just to clarify that, because I know that's something which some people have asked me about in terms of confusion of terminology. And again, just really important to understand the written statement is basically contained within the tenancy agreement. So it's pretty much the same thing, but again, the government are using different wording for it. My next slide, just in terms of timing. So I've taken this from last week, so you'll notice this from last week's slide, but I just wanted to make sure everyone's fully aware of it because obviously the timings are really important. So there are 2 lines in the sand, if that's the right way of saying it. So the written statement wording, which is on the webinar I did last week, that will only apply to any tenancies that you sign and execute or create on or after the 1st of May. So any tenancy agreements that are signed and dated and executed after the 1st of May, on or after the 1st of May, the written statement requirements, i.e. the wording in the tenancy agreement, will be required for that type of tenancy agreement. So again, most of you won't have a verbal tenancy. If any of you got a verbal tenancy, as in there's no written agreement for a current tenancy now, then you would need to provide a copy of the written statement to that tenant prior to the 31st of May. So you would draw up a brand new agreement on the 1st of May for any verbal tenancy that you have, which is unlikely for letting agents. I'll be very surprised if any of you have got a verbal tenancy, but there might be some landlords who've done it on a gentleman's agreement. So again, they would be obligated to provide a written statement, as in a tenancy agreement, to that tenant prior to the 31st of May. So that's currently. And then the other one, which again, just to flag up, because it may happen, is where there's a change from one tenancy to another. And probably the most common example of that is where you've got a non-Housing Act tenancy, and then the circumstances of the tenant changes to make it an assured periodic. So it's not someone's main residence. So you would use a non-Housing Act tenancy or a common law tenancy if you want to refer it to like that. And then their circumstances change and it becomes their main residence. You would then need to give them the written statement within 28 days of that situation happening. So again, unlikely that's going to happen to you, but just need to be aware of it, because obviously the penalties are quite severe if you don't do that. So you might have given a non-Housing Act tenancy to a tenant for a particular reason. If their circumstances change and they are now falling under the new regime under the Renters' Rights Act after the 1st of May, then you have 28 days to provide that particular tenant a copy of the written statement. And obviously that would be by creating a tenancy agreement. So just in case that ever happens to you, just need to be aware of that. And then the other one is prior to the 1st of May, any tenancy agreement that you've executed and signed or current, you would then have an obligation to provide the information sheet, which we'll talk about in a bit more detail on the next slide, because I know that's something which obviously lots of people are doing now, purely from the fact it's so relevant. That's probably the first big job that people have done. I'd be really interested to see if anyone's done it yet. Has anyone sent it out yet already? How are you sending it? How are you evidencing it? I'll be really interested to hear people's points of view. A couple of people said they've started sending it out. So I'd be really interested to hear how that's gone, what response you've got back from the tenant, how much you charging for doing it, whether you're going to send it out as late as possible. I'll be really interested to hear that. So I'll be really interested in your feedback. You don't have to say it here. You can obviously just send me a direct message if you wish, if you don't want to enlighten other people on this webinar. But yeah, I think we're all friends to a certain degree. So I'll be really interested to see how you do it and how it's received by the tenants in terms of what response you get in terms of evidence, etc. So the bottom one's about any tenancy that's created in existence prior to the 1st of May. So you can sign and date and execute a tenancy now, which starts after the 1st of May, but you would use a current tenancy today, but you would then need to give them a copy of the information sheet as you're fully aware of it. So that's how it works. So the government information sheet, the interesting thing, I mean, I was expecting it to contain all the information which the written statement contained, but it doesn't. It contains like 70% of it. So it's really strange. I don't really understand that. If anyone can give me any logic to that, you thought it would be almost exactly the same as the written statement. If you're saying to a tenant, you need to know all this information, then I don't really understand why a current tenant wouldn't need to know that as well, if that makes any sense to you. But again, the logic doesn't really make a great deal of sense. But then again, that's probably this government. Without getting too political, because I know some people will tell me off for being too political, but it makes no logical sense to me whatsoever. But that's not unusual for this. Jane, hand delivering, you're going out on a day, you're going out on a road trip, fill your car up with loads of information sheets and away you go. So I don't know if people can see all the messages, can they? Can you see all the chat going backwards and forwards? Can anyone tell me if they can see all the messages people are saying? Yeah, you can. So Louise says, yeah, the hand rent guide is no. The hand rent guide is not relevant anymore. I think I said that. I would argue it's not relevant anymore because it only really applies to a section 21. So do you need to serve it? I would say no. There's no obligation to serve the last version of that. And to be honest, it'd be out of date anyway, wouldn't it? The how to rent guide. I'm just trying to think what it says on there. But it would be out of date anyway, wouldn't it? Surely on the 1st of May, most of it, again, if anyone's really sad and has read it, can anyone read it for me and tell me what's in there? But I think from memory, it's going to be out of date, isn't it? It's going to be irrelevant. So unless they produce a new version of the how to rent guide, which is unlikely, then I would say it's going to be irrelevant. Does it have any impact on regulated tenancies? Assuming, yeah, no, it doesn't, Steph, in terms of the written statement. That's probably a question you asked me about the written statement. So yeah, it doesn't affect Rent Act tenancies. They're outside of it. So most of you are going to be sending it by email. Some people, Sarah, are charging, not charging. Some people include it within the price. Some people are charging because there is an amount of work to be doing. Some people are, yeah, I'll be really interested. No one's put their. So I went to do a training course with I won't mention them, but I did it in-house last week, and they said 35 quid they're charging. So £35 for managed, I think double for non-managed. And most of their landlords have said, yeah, please serve it for us. Hand delivery, yes. I can't remember what the question was now, but yeah. So yeah, the interesting thing is it's not it doesn't contain all the information which the written statement contains, which is interesting. The other thing that which lots of people have said, or a couple of people have mentioned, they thought you could only serve it between the 1st of May and the 31st of May. You can serve it now up until the 31st. Well, actually, I would probably say if you're including service time, the last day you're going to serve it is the 28th of May. I don't know if anyone's going to say they're going to serve it as late as possible. I don't want my tenants to know anything about this until the latest date. So I don't know if anyone said that, have they? Or if you're really lazy like me, then the 28th of May is probably quite a good date to send it out. But I think that's the latest date, the 28th. But yeah, you can serve it now, anytime between now and, well, whenever it was. When was it published? 9 o'clock last Friday. I think John and someone else. I was in bed still on Friday, and I got a lot of emails telling me that the information sheet had arrived. It was someone else. I'm trying to think. It was the lady. What's the lady's name at Southernbrook, Steph? I'm trying to think of her name now. Louise Sidekick. I should know her name. Apologies. But yeah, she was the first person to tell me that I was too slow off the blocks. Any tenancies prior to the 1st of May, so any tenancy agreement that you create prior to the 1st of May, or that's in existence prior to the 1st of May, the information sheet would be applicable to. Now, the other thing I want to make you aware of, because there's a world, I mean, I might be completely wrong on this, but I don't think I am. So there's a world of difference between what legislation requires and what the government guidance is. So I've sort of drilled it down. So I think on my YouTube video, which I did a couple of weeks ago, I think I mentioned that you should serve it to all joint tenants. Because I can understand the logic, because if you give a joint envelope, if you give one envelope to 4 joint tenants, and one of the joint tenants opens it, and there's a good chance the other 3 don't see it. So I can understand the government's guidance to say you should serve it to all joint tenants. So from a belt and braces perspective, if you're serving it by hand, you're going to have to serve 4 separate envelopes with 4 separate names on there in terms of joint tenants, because logically, I would argue that makes sense, that, you know, each person would need to know the new rules. So it's only fair that you would have to send them 4 separate envelopes physically if you were serving it by post or by hand. If you're serving it by email, then you can serve, obviously, you can serve 1 email, but it would have 4 email addresses on there. So they would all independently get that email. So I would argue the joint tenancy service is absolutely correct in terms of belt and braces. Although I've looked in the legislation and I can't find it. It doesn't make any reference. It just says served upon the tenants. So the question then would be, is serving it on 1 tenant sufficient? But the government guidance goes further. But as you know, government guidance isn't law. It's only what the government said you should do. And as you all probably know from one of my famous court cases, Super Strike, they were saying you didn't have to protect the deposit again when it went periodic. And the court said, no, you do, actually. You have to do it. So they overruled the government. So from that perspective, I'm not saying the government guidance is wrong, especially on joint tenants. I think it makes logical sense to serve it individually to all joint tenants. But it's only government guidance. And you can see on my slide, I've broken it down where I think it's government guidance, which is only someone in Whitehall saying you've got to do it this way. Whereas the legislation, which is what I always look at, you should always drill down into the legislation, say, actually, what does the legislation say? And the legislation doesn't make any reference to it being served to all joint tenants. It just says tenants. So take that how you wish. But if I'm being honest, practically, it makes sense that you do serve it to all joint tenants. Yeah, Sarah, I mean, I don't want to keep reiterating my famous phrase, but yeah, let me know how you get on with the council and let me know. All I can really say is I had a conversation with So I work with a couple of councils. I've got a really good friend now who's actually the renters' rights manager at Bournemouth and Poole and Christchurch Council. So she said to me, actually, Daryl, she used to be one of my clients, funny enough. She used to work for an agency. So they're employing people that have some element of landlord knowledge. So each council is a member of Jigsaw, which is like a national framework for local councils. So they meet monthly at the moment, from my understanding. So all the renters' rights managers for each local council have I assume, a webinar. So they all just discuss enforcement. So she phoned me up, funny enough, the other week talking about training. And I said to her about the government information sheet and said, how is that going to work? How are you going to enforce that after the 1st of May or after the 31st of May if a tenant comes to you and says that the landlord or the agent hasn't served the government information sheet? And she's told me this is how they're going to work from a Bournemouth and Poole and Christchurch perspective. They're going to be educational, especially around landlords who haven't done it. And they're not going to fine them straight away. And they said, we're going to give them the opportunity to serve it if they haven't. And then if they still don't do it, we are going to fine them. So they're going to be very educational around landlords in particular. Not too sure about agents. I simply don't know how they're going to work with agents. But with landlords in particular, especially self-managing landlords, she said there's going to be a lot of wriggle room for them. So in terms of non-compliance, the councils won't be as onerous upon them. But again, each council is going to be slightly different. So I don't really know, Sarah, in terms of your question, is what evidence do you need? Ideally, I know belt and braces, as always, is that I want some confirmation from them that they've received it. That would be my absolute belt and braces. If you haven't got that, then just need to make sure that you can prove that you served it. And one thing I've definitely got wrong, and I apologize for this, is when I was going through the local government guidance, the threshold is not actually on the balance of probability, which I thought was a civil position. The government guidance to local councils is that it's got to be beyond reasonable doubt. Because it's a criminal prosecution, potentially, it's the criminal threshold. So the councils need to prove that it's beyond reasonable doubt that you haven't provided the information sheet. So actually, the threshold is a lot higher for the councils to levy a penalty. So I'm not saying that's going to get you off. I'm just saying there's a different threshold in terms of how they're going to be dealing with penalties. So for the information sheet, it's beyond reasonable doubt. They are pretty confident you haven't served it. So I would argue if you can prove that you've sent it by email, then that probably is going to be enough. But I fully accept I don't want you sending out this recording to the council saying, well, Daryl said this. Obviously, that's not going to work. So, well, not for my, and I'll be on the other side of the planet, so you can't sue me anyway. So from that perspective, just be wary of it. So, yeah, beyond reasonable doubt. So the council would need to prove that the criminal threshold applies. So it applies to any joint tenancy. I get evidence, as I said. I think that's the way I would absolutely do it, irrespective of what I've just said previously. I think that's probably the only way that you're going to be able to do it. The only thing I don't know is how they're going to deal with agents. It's still the same position. They still need to prove on the beyond reasonable doubt that you hadn't served it. So would a mass email, and you can show that you sent out a mass email, would that be sufficient? I simply don't know, but I think it probably would be. Obviously, the ones that where they bounce back, whatever it's going to be, then you're going to probably have to serve them differently. But I'll leave that ball in your court. I can't give you an answer in terms of how I would do it. Well, the answer I would do is I would get someone to confirm that they received it. That's the belt and braces. But do I think an email send, bulk email send would be sufficient? It's likely, probably. Although, as you know, we're going to see a few test cases. So I don't want you to be the first one, obviously. So that's what I would do. So that's the government information sheet in terms of some of the issues that have arisen or people have asked me about. What are people saying? We're sending it. Oh, so the people in there, so Penrith. So Mandy and Penrith is, you include it within your, so you've increased your fees, Mandy, I assume you're saying. Yeah, Louise, I would say if you're going to serve it by hand, you've got to evidence that you are serving it by hand. So yeah, selfie, that type of setup would be the way I would do it, if I'm being completely honest. I know I would also take a picture of what you've put in the envelope. So there'd be a picture of the information sheet going into the envelope, and then there'd be a picture of the envelope by the front door. sadly. That's the way I would absolutely do it. So belt and braces would be my way of doing it. As I said, Sarah, I think email without a digital signature is probably okay, but I would probably want something back from them to confirm that they have received it to be belt and braces. Yeah, evidence, absolutely. Oh, Katie's here, Jack. So yeah, you don't get paid enough, Jack. You definitely don't get paid enough. That's probably what I'm going to say. You can pay me later, Jack. No problem. Government information sheet. So this is the one that this was the one that, again, looking at, because I wasn't even aware that, I mean, if I'm being honest, I had to go and dig down into the Renters' Rights Act, but obviously the government guidance said if you're fully managed and your landlord serves it, then the agent still needs to serve it, which I found a bit strange. But then I had to go and dig into the legislation, and it says actually, yeah, if the person that's managing your property deals with all the compliance, then even if so if your landlord says, no, I don't want to pay you to do it, I'll serve it, as the landlord, the government guidance or the government sheet actually says you have to serve it as well as the agent. So irrespective of what your landlord does, if you're getting paid to manage and do the compliance for a property, then you have to serve it irrespective of what your landlord does themselves. So if your landlord refuses to pay you for serving it and they serve it themselves, you still have an obligation as the agent to serve it, which I found rather strange. And I had to go and dig away in the legislation. Yeah, and you can see it there. It's in Chapter 6, Paragraph 7, Subsection 3, if that's the right way of saying it. So yeah, so it's just one of those situations where you sit there and think, wow, so you're going to have to send, the landlord's going to send it because they don't want to pay you to send it, but you're going to have to send it anyway as the agent, which I found incredible. So they're going to get 2 information sheets for the price of 1. So the legislation actually says that. So sadly, that is absolutely, so just in case your landlord says, I'm not going to pay your fee for doing so, and I'm going to serve it myself, then you would still need to serve it as the agent as well, in addition to your landlord serving it, if you are fully managing that property. Or doing rent collection, I would argue as well, because I think rent collection potentially falls under that. So I would personally serve it as the agent. I'm not saying that you have to, but it's that sort of ambiguous, bit where I think you're providing a service to the landlord. You may not be doing compliance, but I still argue there is a service there. So for me, if you're doing rent collection, for anyone that has a rent collection service, I would still serve it, as in the information sheet. The other one, which again is only government guidance, I can't find it in the legislation itself, but the government said you've got to give them a copy of the attachment. So yeah, I mean, we had a court case about this on deposit protection, if anyone remembers. It was about the information, it was about the scheme leaflet. So the courts at county court decided that you couldn't just give them a link, you had to give them actually the attachment itself in terms of the deposit guidance, deposit scheme leaflet. So I think it's very similar to that. So, but I can't find anything in the legislation that requires you to actually give the attachment. You could give a link, but the government guidance says you must give the attachment, not the link. So I would probably follow that as well, even though I don't think the legislation says that itself. The government guidance says that. And we did, as I said, have a court case on deposit schemes and deposit protection, which said that the scheme leaflet you must give as an attachment. You can't just give it as a link. And then, yeah, the last 2 are we've sort of talked about already. So, yeah, beyond reasonable doubt. So it's the criminal threshold which councils will use. And again, each council is going to be slightly different. I was in Reading last night doing a landlord evening, and I know Reading Council are really awkward. They are a Labour majority council, and they are probably going to be the worst. So even though my council, which is I think Lib Dem run, sadly, they are going to be a bit more pragmatic. So from that perspective, well, that's what my friend has told me. Whether that actually happens in reality or not, I don't know. But that's what she's told me. They'll be much more pragmatic, if that's the word I can say. So, is there any questions on the information sheet? Because I know that's something which everyone's. Has anyone done it all already? Has anyone said that? Someone said they were doing it. Someone messaged me on LinkedIn and said they were almost finished. So I wasn't too sure if anyone else has anyone done it all already? Has anyone been really efficient? It's a week now, isn't it? When did it come out? The 20th, isn't it? So yeah, it's a week tomorrow. Yeah, the deed of guarantee. The the deed of guarantee I'm looking at, Mandy, so I will probably change it. The problem I've got, Mandy, I get up every day and I think of something else what I might need to include in the tenancy agreement. And we'll talk about that later, actually, funny enough, when we talk about, well, strange enough, someone asked me about notice. So can a tenant serve notice earlier than the start date of the tenancy? So I think they were using student lets as an example. So a lot of you, for those that do student lets, so if you sign a student up today to start in, say, September, so you sign in date and execute it today, being the 26th of March, but it doesn't start until September, which a lot of student lets will be doing. So when can that tenant serve notice? Can they serve notice now, as in after they've dated and executed their tenancies, or can they only serve notice when the tenancy physically starts in September? Now, logically in my own head, because I've never really been asked this question before, logically in my head, I'm thinking, I don't think you can serve notice until the tenancy physically starts, as in the 1st of September for student lets. But I just simply don't know, because it's never come across to us before, because obviously this is relatively new, because no tenant's been able to serve notice before, obviously, because it's been a fixed term. But they can serve notice on day one, obviously, now. So everything we now know as letting agents and landlords is going to change after the 1st of May. So everything has a different aspect to it. And that's a question I couldn't really answer confidently. I don't think you can serve notice until the tenancy physically starts, as in the commencement date. So in my example, the 1st of September, even though it was executed as a legally binding tenancy today, as in the 26th of March. So those questions might come up. And I know there's a few student people on here. So Tom's here as well. Tom's got a huge amount of knowledge. I don't know if Tom's got any thoughts on that. But I would absolutely say, I think it doesn't, I don't think you can serve notice until the tenancy physically starts itself, which would be, in my example, the 1st of September. But then again, I would probably, and that's what I would probably do for student lets, I would probably put that in my tenancy, saying the earliest you can serve notice is whatever date your tenancy physically starts. So these are all the little things that come out from conversations that I'm having. So every time that I have a conversation with someone, I sit there and think, oh, actually, does that make it, do I need to change my agreements accordingly? So that's the scary thing about the Renters' Rights Act, that there's lots of discussions about things that I've not even thought of, which is a bit scary if I'm being completely honest. So yeah, Mandy, I will absolutely look at the deed of guarantee, and I think there will be some changes to it in terms of how it's going to be working and in terms of its enforceability as well. So I know you subscribe to the pack, so that will be done prior to the 1st of May. In terms of the information sheet to landlords, Charlotte, to guarantors, I don't think you need to serve it, although good practice would dictate that you do, purely from the fact if the guarantor is guaranteeing the tenancy, then I don't see why they shouldn't know if there are changes to the tenancy, even though the written statement or the information sheet is not a physical change, it's just information. I still think it's probably something I would serve to all my guarantors. I think from my own perspective, I would probably do that as a matter of course in terms of good practice. I don't know if anyone else is doing that. And it'd be, again, interested to know. Legally, you don't. There's no obligation to do so. The legislation doesn't say it. But I think from a good practice perspective, I would absolutely send it out to all my guarantors. Tom mentions, if your email system relies on an email, make sure you have express consent from the recipient to receive communication by email. Yeah, that's a fair point. And I think I mentioned that on my last one, Tom. So my agreements, and they're very clear on there. Well, actually, there's an opt-out and opt-in. So I think in there, when you create the agreement in the first place, the tenant, you amend it accordingly, whether the tenant agrees to it or not. So if you're using my agreement, it very clearly says that. Well, it depends on what you've crossed out or amended. But my default position is that you can receive notices, etc., by email. So again, as I said on, I think the last webinar that I did, I think you can send it by email. So my agreement says that, but again, double check your email, double check your tenancy, shall I say? The reality of it, again, it's just an example. Again, just for me, just in my head, I just thought I'll give you an example of what will happen. Agent is fully managing in terms of compliance, sends out the info sheet by emails and attachment. Tenant doesn't reply, but you've got an email receipt to say that they have read it. Do I think the councils are going to prosecute on that basis? Likely no, would be my position. So again, I think if you've got a read receipt, I think on the balance, not on the balance, beyond reasonable doubt, I think that would go out the window. I don't think that the council is going to prosecute on that. I think they would be wasting taxpayers' money to be doing so. But I fully accept I might be completely wrong. So you've got to bear that in mind. But I think a read receipt is probably going to be as good as getting confirmation from the tenant. Again, I'll be really interested if that's what people are prepared to accept as risk. I don't know. As I said, what I would probably be doing, I'd probably be doing the absolute belt and braces, but I fully accept that might not be that easy if you've got 1,000, 2,000 joint tenants to send information to. So you might just decide, actually, risk-wise, Daryl, we're prepared to accept that. We'll just send out a bulk email, and if we get a read receipt, as in they've opened it, then that would be sufficient for us in terms of confirmation. And I think that in reality is probably how it's going to work. But I fully accept I might be completely wrong, which is always the problem. Any other questions on the government information sheet? I think most people have asked all the questions that no one said they've sent it out. I'm surprised. I thought all of you will be chomping at the bit to get it all sent out. But if you haven't, that's great. No problem at all. Just be interested to know. Other documents, this is just in the round. So between now and the 1st of May, Mandy's sort of alluded to it. Yeah, the guarantor terms deed is going to be amended slightly. Your terms of business, for those that have my documentation pack, my terms of business is in its about 4th or 5th version. It keeps getting proofread. So that should probably be out in the next, I would say, probably end of Easter. So give me 2 weeks over the Easter just to finalize it all, and it will go out to you. That's taken a bit more work than I thought it would do, if I'm being honest. Again, a lot of debating in terms of what should be in there, what shouldn't be in there, what other things that I might need to cover. It doesn't mean that when you get it, you just don't touch it, and then it will still need a lot of amendment from your own perspective in terms of what you charge, obviously the services that you provide, etc. But I think I've covered most of what I need to cover in there, but there's a bit more work to it. I know Jack keeps harassing me for the terms of business. Jack, I'll send you my 4th version. It's still lots of scribbling on it in terms of someone's written all over it for me. But I can send it to you if you want to have a look, Jack. You're more than welcome to have a look. Give me your honest opinion. Delays again, yeah. Well, I'm a Tottenham fan, so it is a bit depressing at the moment. So that's probably my my excuse for not providing the terms of business on time. I'm still crying every weekend. So yeah, the terms of business will be out probably in the next week or so. Contractor terms, again, mine will be amended slightly to take into account the more importance of getting your contractors to provide evidence about repairs, etc. Contracts with other third parties, again, that's open to obviously definition, sort of your own definition of that. The property ombudsman, I don't know if anyone's heard from them, but I can't see that they've changed their terms yet. I assume on the 1st of May, their terms will definitely change. Your membership rules will change. So again, from that perspective, there will be a lot of reading that you might need to do. I don't know if anyone's had any information from rent guarantee companies in terms of any additional obligations they may have upon you. So again, all of these things are going to happen quite close to the 1st of May. So from a business perspective, that week is going to be really busy because we simply don't know what's going to be sent out to you and what potentially you might need to then take into account when you're dealing with things. So again, just be really wary of that. And that week, I would really keep an eye on all your emails that are coming through to you, because there will be lots of amendments to terms and conditions from different people, which may mean that as an organization, you're going to have to work in a slightly different way. The deposit schemes, I've asked them, but they've all ignored me apart from my deposits, who said, we'll let you know as soon as, Daryl. So all of the schemes will change in terms of obviously what they're going to charge, how they're going to work, when you're going to have to pay a new fee, especially around the insured version, where they make a lot of money, I assume, from annual renewal fees or annual periodic fees, whatever they call them. So everyone's going to have that period. I would probably say, I assume they're just going to all be published on the 1st of May. Probably that's how it's going to work. And then from the 1st of May, you're going to have to read all those terms and conditions and go, actually, is there anything in there that I need to take into account when I'm dealing with a process? So the property ombudsman is definitely going to be one. And you've probably got a little bit more time on that one, in the sense it's only going to be a real issue if someone complains about you. But rent guarantees in particular, and again, I've asked a few people, but they've completely ignored me. Whether they don't like me or not, I don't know. But I assume probably because they don't know themselves. So again, just be really wary of it. So if you were looking to take a holiday on the 1st of May, cancel. So I think 1st of May, for the first week of May, that's going to be a really testing time for everyone, because I would argue you will get lots of new documentation in terms of conditions out. So I would absolutely diarise that. And again, please let me know, because I don't get everything from everyone else. So if you get something from someone that says, oh, actually, you've got to do this, I would be really interested in knowing it, purely from A, from a nosiness perspective, and B, I can tell everyone else. So we're sort of like a community, if that's the right way of saying it. So I get a lot of information from other people as well. So that would be really welcome from a DWK perspective. Yeah, Morris Dibben, who are they? Are they part of Countrywide? I'm trying to think. Yeah, Countrywide, Foxtons, all the corporates, mate, are going to be charging fortunes for this. Yeah, Charlotte, I fully accept. Yeah, I mean, you're not going to tell them that, are you? But I think from that perspective, I think there's an element of work. Yeah, I'll leave that ball in your court, depending on how transparent you want to be. But yeah, there's no reason why you can't charge for it. In the end, it needs to be sent. So it's another element that you need to do. So it's part and parcel of being a letting agent, sadly. I like the abuse I'm getting from Jack and Katie. I mean, aren't Portsmouth going to be in Divi 1 next year? So I would be quiet if I was you, if you're complaining about being relegated. We have sent to all our managed. So John's saying we have sent to all our managed tenancy units via our marketing software, and we'll be saying it via our RCM. And then again, you're going to send it 3 times, John. Beautiful. Yeah, I suppose in the end, I'm sure one of them will land, won't they? It's yeah, it is bad. I was in Southampton the other day, and they were all laughing at Portsmouth. So yeah, just in terms of other documents, just be wary of that. I'm mindful of time. I've talked too much already. Section 21's just to reiterate it, because I know it's popping up. Section 21. So I won't bore you there, because that was on my renters' rights update. But as you know, the last possible date, although solicitors have told me they would say they wouldn't allow it any later. I think one solicitor said the 20th of April is the latest date that they would say you could serve a Section 21. But I would argue if someone wants to serve a Section 21, so long as all the compliance is in place, then the latest date you can send it is the 27th of April or somewhere around there. So 27th, 27th, because there's 3 days before the end of April. So anyone that's still looking to serve a Section 21, you can still serve it, so long as all your compliance is in place, and so long as you serve the How to Rent guide, obviously. Then you can serve your Section 21. At the latest date to include service time would be the 27th, which I have no idea what date is. The 20th. Is that my birthday's on the Saturday? I think. Is it 25th? Is the Saturday, I think, off the top of my head. So the 27th is going to be a Monday, I assume. I think it's a Monday. So yeah, that's the latest date you can possibly serve a Section 21. Yeah, so you're more than welcome to send me a present on the Saturday. I'm an old man, even older on the, I'm even older on the 25th of April. Yeah, so Section 21. Yeah, so just on your slide is what I've said. So you can send it out, and then you've got that 3-month transitional period to send it to court. And get the courts to process it, which is the other issue that you need to be aware of. So we've got a county court case on that, where the judge said it's the processing by the courts, which is the line in the sand, not just the submission to the courts. So just be wary of that, because obviously courts are taking a long time to process paperwork. So you could get it in June, the 1st of June, you might get it in. But if it takes them 3 months to process your paperwork, then you're going to be outside of the transitional period, which I know sounds crazy, unfair to a landlord, but landlords need to be aware of that. So from my perspective, if you haven't served a Section 21 now, you need to get your skates on and serve it, get it in, expires end of May, get it into the court straight away, and hopefully within that 2-month period that they will process the paperwork. But some courts take a lot longer than a couple of weeks to process the paperwork. My court's really quick. Actually, they turn it around in about a week, as in when you've submitted it, they take the fee, and then they will send out all the court paperwork to you and the tenant within a week. So they're quite quick down in Bournemouth. I don't know what other courts are like. London in particular is an absolute nightmare. So just be wary of that if you are looking to serve a Section 21 notice. The same applies to Section 8, which is, I think, my next slide. Oh, no, it's not. Ground 4A, sorry. Apologies for non-student landlords. You can fall asleep for a bit. So logically, I was working out in my head. So I put 2 lines in the sand. So I know John and Jack will deal with student lets. I know a few others may do. So the ground 4A notice. So for this student year, so if you're looking to serve a ground 4A notice in this student year, you just need to send out a pre-notice. On the 1st of May, a pre-notice could be a simple email or a letter to the tenant saying, by the way, we're going to be relying on ground 4A. And then you serve your actual ground 4A notice under a Section 8. So you can serve your pre-notice on the 1st of May, give a few days for delivery, so it gets to them on the 4th of May. And then on the 4th of May, you can then serve your Section 8 under ground 4A. I mean, as you can see on my slide there, I would just serve a Section 21 for this student year, if I'm being completely honest. I would probably completely forget about the ground 4A for this year. But I'll leave that ball in your court. I'd be interested to see what John and Jack are saying with our guard and ground 4. But for this student year, I would probably just serve a Section 21, if I'm being completely honest, if that's what you want to do. That's probably the easiest way of doing it. For the next student years in 26-27, if they've already signed up 6 months prior to their occupation, then you can't use ground 4A, obviously, for the next student year. If you are going to use ground 4A and they've not signed up 6 months prior to their yeah, John, your point's very valid. I don't know if your tenancies end, but yeah, you are right in that scenario. But I think most of them will end the 31st of July, but you might tell me differently. I fully accept that. But for the next student year, yeah, if you are going to use ground 4A, you can't use it, obviously, if you sign them up 6 months prior to occupation. But if you haven't done that, then you can use ground 4A and you've got 1 month to serve your pre-notice to them that you'll be using ground 4A or potentially using ground 4A for the 26-27 season. And then you've got to give 4 months. So just be aware of it. So there are 2 different scenarios potentially, depending on which student year you're trying to end. So ground 4A is going to be applicable or available to you if you have a HMO student setup, as in 3 or more people who are not all related. That's the definition of a HMO. Section 8. Very exactly the same in relation to the transitional period. So if you've served a Section 8, as you might be aware, the Section 8 notice has a 12-month service lifespan from service. So again, but you will have to use it or lose it by the end of July. So the 31st of July will be the end of your Section 8s that you served prior to the 1st of May. Any Section 8 served after the 1st of May would fall under the new rules. I don't know if anyone's got a Section 8 that they've served or looking to serve, but the same transitional period applies. You've got until the lifespan of the Section 8 or the 31st of July to start court proceedings. And because the lifespan of a Section 8 is 12 months, it's going to be the 31st of July, which is your big line in the sand. But again, the same applies in relation to possession claims, as in the courts must have processed them. But if you use possession claim online, which is the rent arrears version of the possession route, then that will automatically send out the court paperwork. So in a sense, that's quite a good way of doing it. So if you have rent arrears only, then possession claim online is the online facility for court paperwork. And I would just do it via that system if anyone's done it, and that would automatically process your paperwork. So that removes the danger of the courts taking ages for them to process it, but that only applies to rent arrears only. So if you're using grounds 8, 10, and 11, then the possession claim online is the online version of the court system, which is the best system to use. And I'm going to assume that's going to be available after the 1st of May. I've not been told it's been taken away, but we simply don't know. I assume that will still be available to you after the 1st of May. Section 13. So yeah, a couple of you have asked this question. I know John's asked this question. Again, it's sent me thinking, okay, how does a Section 13 work? Because no one's ever really asked, is there an expiry date to Section 13? Because in a sense, you're giving someone prior warning that their rent's going up in 1, 2, or 3 months' time. You don't normally, no one's ever really done it, that your rent's going up in 6 months' time. But there are some people that are looking at to increasing the rent in, say, August or September using the current Section 13. So I've been asked that question, and the question would be is, can we do it that way? And I legally think you can. I'm not too sure if there's any real negative from that. As in, I'm not aware of the court saying you can't do it, but no one's ever done it before, obviously. So some people are doing it. I know, without nailing you to the mast, I know John's asked that question. I don't know if anyone else is looking at it about increasing the rent for maybe June, July, or August now, as in serving a Section 13 now. So you can. There's no reason why you can't do it, because all you need to give is a minimum of a month's notice to start on the next due rent date. It doesn't say a maximum. You could give 12 months notice in theory, or even 2 years, but no one's ever done it because it's never really been something that you would do. But obviously under the Renters' Rights Act, people are now thinking of different processes and different things. So can you serve a notice now under a Section 13, giving more than 1 month's notice to increase the rent in June, July, August, or September? Absolutely. I don't think legally you can't do it. I've just never ever seen anyone do it, which is always the problem, because we don't simply know how people are going to react, what the courts are going to say potentially, what the first tier tribunal is going to say. We simply don't know. So just be wary of that. But in theory, you can serve it now to start for a rent increase after the 1st of May. Just got to follow the current rules, which is Section 13 notice, and you must give at least 1 month's notice to start on the next due rent date. But you can give more than 1 month. You can give more than 1 month's notice if you wish. The tenant still has the ability to dispute it as current. The tenant still has the ability to negotiate. Obviously, the only difference between now and the 1st of May is obviously any decision would still be backdated to the rent due date, or the rent date on your notice. So that's the big difference between serving it now and after the 1st of May, obviously. So again, I'm not too sure how the courts are going to view it. It'd be really interesting, and I'm sure there will be a few court cases on it or a few decisions which will interest people like myself. So just be wary of it. So you can still use it now to increase the rent after the 1st of May if you want to do so. Obviously, after the 1st of May, then you would need to use the new Form 4A, which is still draft version. As you know from my email, the Section 8 notice and the new Section 8 notice are very similar. I think they're almost identical, give or take a few words, and very similar for the Section 13. It's almost identical, bar a couple of minor changes. And I will run a couple of webinars on how to complete a Section 8 and how to complete the Section 13. I'll probably do that prior to the 1st of May. So probably the end of April I will do it, and then I'll make it available for you in my private YouTube channel, and you can download it or watch it if you're ever filling out Section 8 or Section 13. So that's the Section 13 in terms of pre 1st of May and post 1st of May. Yeah, there is a lot of stuff given. Yeah, it's a lot of time, Katie, in terms of how long it's going to take for someone to serve notices. But I fully accept people will have. That's where you need someone on work experience. That's what I did, work experience. And I went to a solicitor's and they put me in a filing room for 2 weeks. So I used to get all the files out in the morning, and I had to put them all back in the afternoon. At the end of 2 weeks, they gave me 20 quid. Incredible. But it just, it's one of those things. So get someone in from the college, the local college, to do it for you. That's probably the way of doing it. It's a bit more interesting as well, I think, than filing anyway. Oh yeah, I know some people use Good Lord. So one of my clients, I'm not the greatest fan of Good Lord. Don't tell them that, but I appreciate they are a good system, and lots of people do use them. So I can't slate them too much. But my understanding is that they will be sending it out for you on the 1st of May. So they're going to be collating all their data. I just be very careful about putting on people's data that have never gone through Good Lord before, because I think Good Lord are asking you to put on all your data. So just be wary of that. I'm sure they've probably looked into the data protection issues there, but there's only one reason Good Lord want all your data, and that's basically to market all your database. I would probably say set up sell utilities and all that malarkey. So I'm not saying that's probably what they're doing. I don't know, but they're doing it for free. They want all your data. So just be very, very careful about what information that you give Good Lord would be, or other systems which may be offering to send out the government information sheet for you for free. Because as Katie was saying, people don't do anything for free these days. There's always an element or an angle. I'm probably the only person that does stuff for free, just to let you know. without any angles to it either. Rent in advance, just to make you aware, again, you're probably fully aware of it, but again, from an accountancy perspective, your property management software systems probably won't let you take the first month prior to the signing. But as you know, you can't take the first month's rent until the tenancy agreement has been executed legally. So you can take the holding deposit. You can take the tenancy deposit, but you've got to bear in mind the 30-day limit. But you can't take the first month's rent until the tenancy agreement has been executed, which is something which I know is causing people a few angst to it, and it makes no logical sense to me, but the government have said that, so just be wary of that. And again, during the tenancy itself, you can't ask for the rent any earlier than the rent due date. So my agreement has the words in advance removed. As you know, it will say the rent is due on the 1st of each calendar month in advance. So that in advance has been removed from my tenancy agreement. And I assume all the other providers are doing that as well. So you will not be able to ask for, invoice any of your tenants prior to the rent due date. So just be aware of that as well. So again, from an accountancy perspective, your accountants team will have to work slightly different in terms of how you invoice and ask for money from people, A, before they move in, or before the agreement's signed, and also during the tenancy agreement itself, as you are probably aware. So the accountants part of it will change as well. I appreciate I'm already talked too much in this 55 minutes, so I'm going to go. I'm probably going to run a whole webinar on its own on this one, because I know this is something which always comes up, and this will be, I think, a perennial problem about joint tenants, etc. And I know I've covered this every single legal update I've done, because I think this is going to be a real pain. So joint tenants notice, as you might be, I've actually put in my agreement, and I'll be really interested to hear your points of view, because some people have told me I don't think we can put it in there. I've put in a clause in there when in the tenants notice that all people must agree to joint tenants notice being served. Now, I fully accept I might be completely wrong. I fully accept it might be completely unenforceable, but I've put it in there. Now, my subscribers to my tenancy agreement pack can take it out, leave it in there, do whatever they want with it. But I've put it in there as a clause that you can edit, remove, do whatever you want with. So that's what I would probably do. I feel except I'm on that sticky wicket, because I think this is going to be a real perennial problem. Now tenants are all periodic. Any one of them can serve notice on day one, and that will end the tenancy for all of them 2.5 months later, potentially. So I think it's going to be much more of a problem than people are thinking. It's not even really being discussed. I might be just talking in my own head about it, but I think it's going to be a real issue. So for me, it's something which you need to be really mindful of. How will you deal with it? I think one of my clients got ChatGPT to do a really good sort of flow chart, and I'll see if he can let me use it or give it to other people, because I think it's a really good way. So it's basically any members of your staff, if they get notice from a joint tenant, they then go through that flow chart and decide what they need to do. Because I think you've got to be really proactive. So as you know, any joint tenant can give notice to end the tenancy for all of them. They can give notice in any way, basically. They can do it via your social media channels. They can do it via WhatsApp. They can do it via text message. They can do it via an email. So there are lots of ways they can validly serve notice. But the notice needs to be at least 2 months long, and it must expire on the last day of a rent period for it to be valid. So again, there are a few pointers there. You need to check, is the notice valid itself in terms of length? And then proactively, you've got to go through that flow chart and work out, what do I now need to do as a property manager? What do I now need to tell the landlords? And probably even more importantly, what do I need to tell the other joint tenants who may not even be aware that one of them or one of their other joint tenants has served notice? So joint tenants, and again, you can find a video on my YouTube channel, which was done during the COVID period, funny enough, which is still almost valid today. There are a few changes, but as a general rule, that video is still 100% valid. So if you get a chance to watch it, it's from, I think the whole video is about an hour long, but you only probably need to watch it from 29 minutes onwards. So it talks about joint tenants and one given notice. So about 29 minutes, I talk about it for about 25 to 30 minutes. So for me, it's something which I think all of you need to look at, because all of you will have joint tenants, whether it's husband and wife, two friends sharing, whatever it's going to be. There will be lots of your tenancies that will be joint tenancies. So for me, that's going to be the biggest issue, I would argue, under the Renters' Rights Act in terms of trying to deal with the complexity. So if my if my client allows me to send it out to everyone, it was a really good flowchart. It was about 4 or 5 pages long, but I thought it was quite good in terms of it just gives a very simple layman's explanation of what someone needs to do in terms of action points. And for me, that's probably the way I would do it. So all members of staff know if they get notice from one joint tenant, what they need to do. But on my slide, as you can see there, it just goes through what I've sort of discussed earlier. But for me, the most important point is the one in the turquoise blue, the reform color, unless I upset anyone. Yeah, the proactive process. What can you do in terms of how you deal with it? And I think that's me finished, pretty much. I might be wrong. There might be another slide hidden away. Is there a summary? There is a summary. I think it's just pretty much summarised what I've just talked about. And I know I was bang on an hour, so probably a little bit longer than I envisaged, but because I know it's a Thursday morning. Is it Thursday? Yeah, it's Thursday. But if there are any questions, I will probably do a couple of other webinars prior to the 1st of May, because I'm sure there'll be lots of things that people will ask about. But I think I've covered the majority of things that I get questions about at the moment, and I fully accept that may change between now and the 1st of May. As I said, just to reiterate from my documentation pack, people, that will probably be ready to download in its entirety by the end of Easter. So probably 10th or 11th of April is the latest I will send it out by. But if you want to see a copy of the tenancy or my 15th version of my terms of business, you're more than welcome to see them. Just send me an email and I'll send it to you. But apart from that, that's me done, I think. I know there's been lots of questions. I have recorded it somewhere. Up at the top, I've pressed the record button. But beyond that, that is it. And as I said, for those that weren't here initially, I'm still here. I'm in some dodgy hotel room in Slough today. So if anyone's ever been to Slough, don't need to come. It's an absolute dump. But apart from that, I wish you well. That's it. Yeah, job done. I will, again, have a great Easter. I'm not going to do anything over the next 2 weeks in terms of webinars, because I know most of you will be on holiday and you probably do need it prior to the 1st of May. But I will still be 100% about. Don't hesitate to contact me, email, WhatsApp, phone calls, whatever you need to do. As I said, I will definitely run Section 8 and Section 13 webinars, and I will upload them to my private YouTube channel, so only my clients have access to it. And then you can just rewatch it if you're filling out Section 8 or Section 13. But if there's any other subjects that you want me to cover, then absolutely, I'm more than happy to do that. Otherwise, I wish you a happy Easter, and hopefully Tottenham will get a few. Well, actually, we're not playing for 2 weeks, so we don't actually play until after Easter. So I'm going to be relatively happy for the next 3 weeks, so there's no football on. Otherwise, I wish you well, and I will see you after Easter. Thanks, guys.